afternoon to you all, and welcome to our first keynote plenary session of the conference. It's my enormous pleasure for this part of the conference to present Professor Maja Janmyr, who's a professor in international migration law at the Faculty of Law at the University of Oslo. I'm sure that Maja is known to many, if not all of you, but I hope you'll bear with me whilst I spend just a couple of minutes going through some of her very, very significant achievements. The first of these achievements requires a prop, which is a book published in 2014 called Protecting Civilians in Refugee Camps. And this is, I think, Maja's doctoral thesis transmuted into a book and was the first in the International Refugee Law series, book series, and thereby set an enormously high tone for everybody else who published there. A fantastic piece of work that very much exemplifies the combination of international law and anthropological approaches that Maja brings to her research. Keeping on the subject of books, Maja's current research agenda is to construct a more global perspective on the nature of international refugee law by focusing on the role and practice of states that haven't ratified the 51 Convention. And this focuses predominantly on states in the Middle East and South Asia, traditionally seen as exceptions. The idea behind this research is to bring the states from the margins to the fore. And I'm very pleased to announce that in a matter of a few short months, in the display table outside, you will see non-signatory states in international refugee law, a new book in the series, edited by Maja, Özlem Gürkay-Skribeland, and Arjun Bamla Kazmi as well. So a really great piece of work. I've seen the proofs and really looking forward to actually seeing it on the shelf in its finalized version. Now, all of this work very much speaks to the approach that Maja has spearheaded to some extent within the field, studying international law from below. And she's very much interested in how refugees and other migrants understand and engage with legal norms and institutions. And on the other hand, how international refugee law is interpreted and implemented in local contexts. Of course, this work draws very much on sociology and anthropology, and the title of today's keynote, Rethinking Refugee Law from an ethnographic, through an ethnographic lens, very much speaks to that subject. So Maja will be speaking for about half an hour, and then we should have 20 minutes or so for a discussion or questions and answers. So, with great pleasure, over to you, Maja. A warm welcome.
Thank you so much. Good afternoon, dear colleagues. I'm so glad to see so many of you are still here. I know it's been a very long and fruitful day, and I heard before David interrupted the chatter in the room. So that's really sounding really good to me when it comes to the discussion in the Q&A session as well. Thank you also, David and team, for the invitation for me to come and kickstart our discussions on social science methods and refugee law. It's really an immense pleasure to be here at the RNI again to talk about this topic. So a couple of months ago, I had the great fortune of visiting the law school at Lums University in Lahore, Pakistan. At one point during my visit, I had tea with a Lums colleague who told me about their empirical research on Afghan refugee children born in Pakistan and the resultant thorny questions of statelessness and citizenship. They painted a very vivid picture of what it was like to do empirical research on this topic in Pakistan, about the dusty sidewalks of megacities like Karachi and the narrow alleyways of bazaars in rural towns, about frequenting the halls of power in the nation's capital, Islamabad. And at one point I asked whether it would have been possible to understand this topic without such an interdisciplinary approach. And they responded immediately, not the slightest. And I mentioned this because my Lahore conversation is really the only latest interaction that I've had with law colleagues across the globe that have reaffirmed my belief that to really understand the workings of international refugee law, we often need an empirical, many times ethnographic approach. And certainly in international law more generally, we've been hearing broader calls for an empirical turn. And in our field, these calls have recently been extended by our colleagues such as Thomas Gormotop Hansen and Dan Geselbach, who just recently co-edited a special issue on what they call transdisciplinary approaches to international refugee law in the Journal Refugee Studies. I hope many of you have seen that special issue. And in that special issue, they really voice a need for what they call methodological heterodoxy, and argue that international refugee law has become, and here I quote them, increasingly insulated from other parts of refugee studies, due to what they say is an absence of interdisciplinarity and a long-standing separation between law and politics in doctrinal legal analysis. So while I agree that it is a problem that we have a lack of interdisciplinarity in the study of international refugee law, I don't really believe that it is a problem that is increasing. My experience over the years is actually quite the opposite, that there is a growing recognition of the many ways in which international refugee law is shaped by and shapes networks of cultural, political, and economic relations that crisscross local, national, international, regional, and global domains. And I think that I've been invited here today with a very distinct request from the organizers to, from the perspective of a refugee law scholar, reflect over how social science methods are relevant for legal inquiry is, I think, testament also to this growing interest that we have in the sort of the combination of international refugee law and social science methods. So having been asked today to speak from experience, I thought that I would share some examples of what I, as a refugee law scholar, have resorted to ethnographic approaches. And I will not only make the argument that by adopting an ethnographic lens, we're able to, in a sense, rethink the application of refugee law, but I will also argue that there are many pitfalls and dilemmas related to such an endeavor that I'm sure many of you who have engaged in the simultaneous applications of these fields have experienced as well. But first, a few words on why ethnography. So, because the doctrinal approach then falls short of explaining how refugee law is created, developed, and implemented, we do need other disciplines to better capture the complexity of refugee law in action. I think most of us will agree about that. Preferably a discipline then that can penetrate the spaces where bureaucratic international law and domestic norms typically overlap, where they sometimes conflict. To me, ethnography is the discipline that can actually do that. But when we hear the term ethnography, I think most of us think about methods, am I right? Yeah, most of us think about methods. And this is even though there isn't really a single agreed upon understanding as to what constitutes ethnographical methods. But broadly speaking, ethnography involves in-depth case-oriented study, including long-term fieldwork and open-ended, often narrative-oriented interviews. And I do believe that these methods, then, they are valuable tools in the study of international refugee law. But what particularly intrigues me, though, as a refugee law scholar, is ethnography's contribution when it comes to questions of power, of knowledge, reflexivity, subjectivity. And in this respect, I think it's fair to say that ethnography is both an attitude and a perspective. And I think bringing this attitude and these perspectives into refugee law research is just as important as engaging with the methodological tools. So just to be a bit more specific here. So ethnographers' insights into structures of authority make them sensitive to questions of power, not only in what and who are researched, but also in how this research is conducted. I'm thinking here about things like the geopolitics of knowledge production, the need for decentering global north knowledge, as well as for decolonizing refugee research. As refugee lawyers, I do think that we must become better at paying attention to the interdependencies of power, knowledge, and inequality, as well as to the colonially created knowledge patterns of refugee research. Ethnography also pays attention to everyday lived experiences and struggles. And for that reason, we have a growing body of fantastic literature that focuses on refugee experiences and understandings of the bureaucratic systems that they need to navigate when seeking protection. And for this reason, I think it's fair to say that a hallmark then of ethnographic research in refugee studies is precisely the recognition of refugees and asylum seekers agency. Equally then, the reflexive turn in ethnographic research is relevant to how we study refugee law. So we can better understand or recognize how our social position shapes the research process, relationships with research subjects, as well as how we represent them and their social world. So power and history work through our texts, through our writings. And as such, it is, to use Donna Haraway's famous terminology, situated. And having said all of this, I'd like to now turn to 3 examples of where I've used ethnographic methods in my research to better understand legal complexities. And I thought that I would start here, in this messy place. I hope you can see the fine writing. Yeah, maybe this one is all right. So one strand of my research focuses on labels and categories. And as you know, this is a major area of debate, also in the positivist literature, concerning the definition of who is a refugee and how a refugee is interpreted and applied. And in my experience then, ethnographic approaches can help us explore the social meanings of the legal concepts defined in international conventions. And much of my research so far has focused on the context of Lebanon, where the legal doctrinal approach was wholly insufficient in helping me understand the concept of who is a refugee in Lebanon. So, together with my colleague Lama Murad, I therefore used other methods to explore how and with what consequences, in this case, individuals fleeing the Syrian conflict to Lebanon were given various legal, bureaucratic, and social labels by humanitarian, state, and local government actors. So a bunch of different levels and a bunch of different actors who were engaged in the labeling and categorization of a specific group of people. And in many ways, I think that our work speaks to the growing recognition in the ethnographic study of law that it is difficult, if not even impossible, to differentiate between formal and informal modes of governance, strictly by referring them to official or unofficial settings. So we illustrate this thorny and complex situation by telling the snapshot story of the Homsi family, where Mother Noor, she works as a teacher in a school near to the family's home. At the time of our research, though, she was at home caring for the family's youngest addition, little Ahmed, only 2 months old. Father Walid, he used to own a small electronics shop in the family's hometown, not far across the border in Syria. He worked now more as a former citizen journalist. He was really engaged in politics of Syria. Nama, 5, and Khaled, 7, they were lucky to be able to attend the school where their mother works. And living with his family of 5 was also Walid's sister Sarah, who had just started volunteering with an international NGO. What makes this Homsi family, like so many other Syrian families staying in Lebanon, is the wide array of labels that they carry, imposed on them by a diverse set of institutional actors. So our study revealed that how each legal, bureaucratic, and social label reproduced a certain mode of ordering each with its own set of implications for what a Syrian may do, how their presence is understood by others in the community, and what types of rights and protections they may have access to. And we could also then unpack how the emergence of labels in one arena often influenced how and why another set of labels took shape in another. So this allowed us then to argue that the categories do not operate distinctly, and membership in one may create constraints and opportunities in another. And I'll just briefly explain this. So in the case of the Homsi family, Mother Noor and her two elder children, they were registered with UNHCR. She had renewed her residency papers on the basis of having a UNHCR certificate, which was possible following 2015. Before that time, it really didn't matter if you registered with UNHCR or not in terms of legal residency on the part of the Lebanon government. Father Walid, however, he maintained that he was not a refugee. He therefore resisted registering as such with UNHCR. But he was still considered by UNHCR to be one of the country's many unregistered refugees. His legal status in Lebanon fluctuated. Sometimes he was living legally, other times not. And for a long time, he was looking for a Lebanese national to sponsor him so that he would be able to renew his residency as a migrant worker under Lebanon's kafala system. However, the informal cost of a kafil was too much for the family, meaning that most of the time he lived irregularly in Lebanon. But what about Sarah? Well, Sarah had spent years in Lebanon without registering with UNHCR. She felt the stigma of being labeled a UNHCR refugee outweighed the actual benefits, particularly because the material assistance that was provided by UNHCR became increasingly limited to those considered the most vulnerable, which was then again another category that Syrians had to contend with. And there's an excellent PhD thesis by Faith Cowley from Oxford looking into the concept of vulnerability in humanitarian settings in Lebanon that I really recommend. When Lebanon in 2015 then changed its residency requirements for Syrians in such a manner that having a UNHCR registration certificate suddenly became important in order to be able to renew their residency in the country, Sarah found herself too late to register properly with UNHCR because the government had at the same time suspended UNHCR's registration activities. And as a result, she was not able to be registered with UNHCR, so she was recorded with UNHCR and thus became one of UNHCR's recorded refugees, which was sort of a very complicated category that officially did not exist. She was left without the option of renewing her residency in Lebanon based on basis of being a refugee. And finally, what about baby Ahmed? Well, being registered neither with humanitarian organizations nor with national and local authorities, at the time of our research, he legally did not exist at all and was at risk of becoming stateless. So as you can see, it was really only through the use of ethnographic methods that Lana and I were able to unpack any of this. The multi-level labeling processes and the mosaic of categories that influence the lives of Syrian refugees in Lebanon. Moving on then to the second strand of my research that focuses on better understanding rights claiming and rights consciousness among Sudanese nationals seeking protection in Lebanon. And this research really emphasizes how the users and the makers of international refugee law are not only decision makers, judges, lawyers, bureaucrats, but they are also refugees and asylum seekers. So for a period of a year and a half, I did ethnographic fieldwork at a protest camp that had been set up on the sidewalk outside UNHCR's office in Beirut. Through interviews and participant observation, I was able to explore the engagements and relations between UNHCR staff and the rights claimants. And through this, I was able to explore international refugee law in action. And then, collaborating with colleagues far more creative than myself, I later turned this research into the graphic novel, Cardboard Camp. And these snapshots that you see here are from that graphic novel, and I have a few other slides with excerpts from that novel as well. And I was interested then in questions like, why and how do refugee protesters choose to adopt human rights language in their claim-making? In other words, how do human rights motivate protest? And how does refugee protest frame human rights? So in Beirut, the Sudanese protesters, they were motivated by bringing an end to what they perceived as marginalization, discrimination. They also wanted UNHCR to reopen closed files and to speed up resettlement processes. We've seen similar calls in other protests elsewhere across the globe. Overall, many of the protesters that I worked with, they perceived the protest to be a very successful strategy. They pointed me to many cases of asylum applications being reconsidered and resettlement places distributed. In my study then of how they framed their cause, it was striking to see how they appealed to and drew on the dominant discursive codes as a way of promoting their interests. So their cause was framed in the liberal internationalist discourse of human rights, often using terms and concepts derived straight from the vocabulary of the international refugee regime. An ethnographic lens allowed me to spotlight how refugees and other migrants interpret the law, which is not necessarily in a way that we as scholars or practitioners do. In this process, the law becomes negotiated, manipulated, tested, contested. Specifically, the protesters' discourse held that their cause was consistent with the values of refugee law, and that they would be justly protected and assisted if only UNHCR implemented its own norms. This is valuable to know for us as refugee law scholars. Finally, in my work, I've also resorted to ethnographic approaches in my quest to better understand the diffusion of international refugee law norms. So when legal norms are localized, they're not just transplanted, right? We know that. They're adapted in a variety of ways. But how? That's interesting. So I'm interested in shedding empirical light on why certain refugee law norms are adopted and internalized, the process by which these norms are implemented, and the interaction between legal and non-legal norms. So in the ongoing Beyond project at the University of Oslo, we make use of ethnographic approaches when studying the relation between the international refugee regime and states that are non-signatory to the 1951 Convention. And our research really seeks to disrupt what we perceive as the hegemonic emphasis only on signatory states in our discussions about international refugee law. We ask questions like, what is the influence of the 1951 Convention in non-signatory states? How do non-signatory states engage with and help create the international refugee regime? And our team then explores the many ways in which IRL norms are spread and used in countries like Pakistan, Bangladesh, and Lebanon. We highlight the role of UNHCR as a norm entrepreneur. And here, ethnographic approaches may facilitate our study of UNHCR from both the top down as well as the bottom up. And there's an exciting body of scholarship taking an ethnographic approach to global legal institutions that really can serve as inspiration here. So our focus is, among other things, on how UNHCR promotes international refugee law. And this includes everything from UNHCR involvement in domestic legal reform to its collaboration with universities in the teaching of IRL. And we've also looked at the usage of UNHCR host state agreements, finding that in many contexts, these agreements are actually being used as alternative protection regimes. And this, I think, raises interesting questions, not only about the sources of international refugee law and the hierarchy between them, but also more generally about the place of the 1951 Convention in today's world. So these examples really just illustrate the breadth of possibilities when using an ethnographic lens to do research in international refugee law. But certainly, as you all know, there's nothing straightforward about interdisciplinarity. And I see so many pitfalls, so many dilemmas. When trying to combine legal and ethnographic approaches, I find that two of the most salient issues relate to knowledge and normativity. And I think it would be a mistake to believe that both fields have a common understanding of what constitutes knowledge, and if, how, and when we should be normative in our thinking. So, when seeking to combine the disciplines of law and ethnography, we must first ask ourselves, and I certainly did not ask myself this when I started off in this field many years ago now, how is legal knowledge created? How is ethnographic knowledge created? How can we create common knowledge? And of course, perhaps the more relevant question is, and the bigger question is, should we at all aim for knowledge production in multiple fields? Or should we, as legal scholars, focus on bringing new knowledge only to our legal community? So these are really key questions, I think, before embarking on any such endeavor. So broadly speaking, we have two choices, right? To try and make a contribution only to the field of refugee law by drawing on insights and methods from ethnographic approaches, or to create knowledge of value to both law and, in this case, ethnography, could be other disciplines. And I think this is a very personal choice related to the goals of the research that we're doing, as well as to the skills and the experiences that we bring into that. But it's also a choice that requires careful reflection, right? Because law and ethnography rely on different methodological, epistemological, and ontological assumptions. So interdisciplinarity involves questions about how truth is formed, about how knowledge is formed, how disciplines see and evaluate phenomena. And there are also ontological stakes involving questions of the constitution of objects and the phenomena that we research. And of course, there are differences not only between disciplines, but also within and across them. I will be the first to acknowledge that the position of doctrinal legal analysis has been challenged by a number of different approaches and methods to researching law. And many of you here today represent these approaches. We even had a panel focusing on feminist approaches just now, but there are others as well, 12 critical legal studies. But the fact remains, I think, that from a methodological and theoretical viewpoint, legal science is not developed at the same pace as other sciences when it comes to reflections on knowledge, knowledge production, and objectivity. So for many doctrinal legal scholars, the belief that legal interpretation can be objective is still regarded as inherent to the field. And doctrinal legal scholarship is, as you know, very much an interpretive discipline involving formal norms and sources, built into certain understandings of authority. I think it's fair to say that it's a very specific genre with a very specific logic, which often entails no methodological training, if we can be frank. When I started off doing my PhD almost 20 years ago, the methods section, which was common for PhD theses in my law faculty, was often merely a footnote with a couple of sentences. I think it's very different today. I hope it's very different today. But ethnography then, as I mentioned, takes as its starting point that there is no objective knowledge, that knowledge is always partial, knowledge is always situated, and knowledge is what we gain when we immerse ourselves in a community by questioning and reflecting. And this knowledge then is always subjective. So these fundamentally different starting points when it comes to questions of knowledge and objectivity might complicate things for us as legal scholars wishing to embark on ethnographic approaches. They do not sit easily with one another. And this also brings me to the issue of normativity. We lawyers love a normative starting point. In fact, I think we're almost obsessed with normativity. But ethnography and many other disciplines count on having empirical knowledge before making any sort of normative assumptions or positions. So normativity then as a starting point in one discipline and empirical data as a starting point in another means that we do not always speak the same language. Far from it. In addition, the lawyer is per definition deductive in their thinking, while ethnographers can't but be inductive, right? Ethnography helps us to apprehend, to understand. So I think one of the hardest things to do, and I'm speaking from my own experience here, is to somehow get away from this obsession with normativity, at least for a little while. And this, I think, is relevant when formulating our research agendas. But also I've noticed when it comes to communicating research that is based on both refugee law and ethnographic approaches. So just to take one example, when I present the Beyond project, that, as I mentioned, empirically focuses on the relation between non-signatory states and international refugee law, to a room full of legal scholars, maybe here, there's often a presumption that the project has, in a sense, a normative starting point. And often that we also take the position that accession to the convention is superfluous and unnecessary, and that we're trying to prove that point, or the very opposite, that we seek to promote accession to the convention, and that's what we're trying to do. But in fact, what we're really interested in is more a social science question, right? We are first and foremost interested in empirically examining its relevance and usage in non-signatory states. And I find that when speaking to a group of social scientists, these types of assumptions are not, or rarely there at least. So I think an awareness about what constitutes knowledge production and objectivity in different fields, as well as the intricacies then of empirical versus normative starting points, are questions that do not have easy answers, but that require reflection in order to answer key questions such as to which field we wish to make a contribution, to which scientific debates do we wish to be a part of. And I'm hoping in the discussion that follows that we can hear your experiences with this, because I do know that many of you have thoughts about this and about these questions. These are inherently difficult issues. Can they be reconciled, if at all? I don't have the answer. And I think it's a very personal reflection that's involved. So this conference then seeks to reunite the debate about how to develop and bridge the field of refugee law and forced migration studies. And I think one way then of, as David phrased it, of unpacking opportunities for mutual learning is then to reflect on the possibilities and challenges that lie in interdisciplinary research. While it's hard to understand refugeehood and the refugee regime without law, if we are curious about how things really work, about questions such as who is recognized as a refugee, not only who ought to be recognized as a refugee, I think there are many opportunities in the usage of ethnographic approaches. So, despite the difficulties of interdisciplinarity, the ethnographic endeavor is, I think, a fertile point of convergence to make empirically grounded and theoretically ambitious contributions to the investigation of international refugee law. If we use ethnographic approaches to better understand core concepts, core legal debates, we may also become, I think, better refugee law scholars. And refugee law scholars who appreciate that refugee law permeates dusty sidewalks and halls of power alike. And refugee lawyers who pay attention then to larger scientific debates about knowledge, subjectivity, objectivity, and normativity. And with that, I think I will end. Thank you so much.